Hello everybody. So they're still doing judges' directions in the mushroom trial. I just wanted to comment on that just to start with. So the trial started and we had 6 weeks of evidence. So it starts with judges' instructions, opening opening statements from both sides, and then we start the actual trial. There was 50 witnesses giving evidence, more than 50, I'm not sure of the exact number, and because then we had the defendant on the stand for, I think it was 8 days. Then we had closing statements, and now we're having judges' statements. So this, look, I mean, trials are at different lengths depending on the complexity of them. I would argue this case is fairly simple as far as they go, because we know what killed them, which is death cap mushroom poisoning. That killed 3 people, and one of them was hurt but didn't die. We know who provided the death cap mushrooms, which is Erin Patterson. So we just have to decide whether or not she did it on purpose. Now, that's not very complicated. In fact, that should be extremely simple. You should just be simply saying, okay, did she do this on purpose? How can we tell if she did it on purpose? Or was it an accident? How can we tell if it was an accident? That's all you have to do. So why the hell were there 2 days of closing up statements for the prosecution, 2 more days from the defence, and we're now up to the 4th day of judges' instructions? Why do we need all that? Now, I'm going to question that. Now, obviously, it's not covered live, so we don't know all the details as to why that's happening, why it's perceived to be this complicated. I can guess, but let's not worry about that. What we can simply say is that they're taking a lot longer than they ordinarily would for a case in which most of the elements are already accepted by both sides. I mean, let's just say that both sides agree, and they have what they call agreed facts, and we know what most of the things are. There's only a few things in dispute. So most of the evidence that was provided was about things that were already established facts, already agreed by both sides, already not in dispute, not in any doubt, which is in 2023, Erin Patterson invited 5 people for lunch, which was her estranged husband. They're still married, but they're not living together all the time. For the last 3 or 4 years, they've been living together on and off. They're not legally divorced, so we can't say ex-husband. In fact, I don't believe they're legally separated. They're just estranged. So sometimes he lives with her, sometimes he doesn't. I'm not completely sure of the nature of their relationship, but suffice to say that they're not always living together. Whether he may well live somewhere else all the time, I don't know. So if this was a case against him trying to kill her or her trying to kill him, you'd have motive. But anyway, but we know that was, he was invited. He, at the last minute, decided not to show up. We know that. Now, what last minute was, whether it was an hour before or a day before, there's some inconsistencies there. We're not completely sure. But suffice to say that he was invited, was expected to come, and then didn't come. Now, then we had the other 4 people were his relatives. So his mother, his father, his uncle, and his aunt. And I don't know which, if it's, I think it's the uncle is by marriage to him. So he's not a blood relative. He was the one that survived. That's Ian Wilkinson. So I believe that he's the one that married into Simon's family. So, of course, you'd still say his auntie and her auntie-in-law, but his uncle and her uncle-in-law. But I don't believe that Ian Wilkinson is related to Simon Patterson by blood, only by marriage. So he's the one that survived. Now, I don't know if that's why he survived. Probably, it doesn't seem as if there was a reason why some survived and some didn't. Now, well, 3 didn't. So there's no disputing these facts, that she served this lunch that was a beef Wellington. Now there is a dispute as to whether it was 1 beef Wellington or 6, and the prosecution are not sure if it was 5 or 6 in their thing. So that's where we have a 1 question mark. But she certainly served a beef Wellington, and she served it from a Recipe Tins cookbook, and we know what the Recipe Tins cookbook says, and it says 1 beef Wellington. It doesn't say 6, doesn't say 5, and in fact there is no recipe in existence to make 6 separate beef Wellingtons served separately like that. So and there were no questions that she asked of her Facebook friends or anyone else that we are aware of asking how to make 6 separate beef Wellingtons. There's also no idea as to how that's even possible. Well, it is obviously possible, but how it's possible within the time frame. Because we've got to remember this is for lunch, and she would have been busy until at least, say, 8:30 a.m. with dealing with her kids, with breakfast, all that sort of thing. And so she would effectively have around 3.5, maybe 4 hours to prepare a beef Wellington. Now that's possible for 1, absolutely. It's about the amount of time you'd have. It's about the amount of time you'd need, because beef Wellington is very complicated. But if you're doing 6 and you're not a professional chef and you don't have access to a massive oven or several ovens, you don't have access to a massive kitchen, I'm going to say that's impossible in 4 hours. Now someone will say, oh no, but we could do it. It would be extremely challenging. Let's just say, like if you went on to MasterChef and you said to MasterChef and you said, all right, contestants, we're going to give you these massive ovens that they have on MasterChef, really wide, really tall, and you get access to as many of them as you want, and we need you to make 6 beef Wellingtons in 3.5 hours. 5 of them have to be poisoned, but you're not allowed to mark the pastry, and 1 of them's not poisoned. You would have these top level, well, perhaps not top level, but the MasterChef contestant on TV with all the access to absolutely everything. They would struggle to do it in 3.5 hours. You gave them 6 hours, maybe, with all that. In 6 hours you can probably do it, with all these ovens, all this stuff. Now you then say to them instead, okay, we're going to give you someone's ordinary house. So instead of MasterChef, you're going to be on My Kitchen Rules, and you're going to be doing it. And you've got 6 hours. They're going to go, we're probably not going to be able to do that. Because they're going to say, we're probably going to need 7.5, 8 hours. And then you tell them, all right, you're not a MasterChef level, you're not even a My Kitchen Rules level, you're an ordinary person level. I'm going to say, no way. No way is that possible in 3.5 hours. But anyway, the prosecution want us to believe that that happened, because if that didn't happen, the case falls apart. The whole case requires her to have made it separately. And this is why I'm wondering why it needs to be this complicated. Because all they need to do is decide, did she make 1 or 6? That's it. And they can very easily work that out. They can say, all right, let's reconstruct making the thing. And they didn't do it. Now I've got to think to myself, and I've been in courts and I know how they operate. It's one of 2 things. Either the defence didn't think of it, or they did think about it, they wanted to bring it in, the prosecution said no, and the judge went with the prosecution. Which is more likely? Well, obviously I don't know for sure, but I'm going to think if the defence didn't think to reconstruct that, they're incompetent, unless of course she's guilty and she did do it and they don't want to do it because it'd incriminate her. So there's 3 options. So one is that she did it, therefore they didn't want to reconstruct it because it would incriminate her. Because if she definitely did make 6, then she's guilty. I mean, this is the thing, she's guilty if she made 6, she's not guilty if she made 1. We can essentially say that. It is so simple. to work this out. Reconstruct it, look at her kitchen, go to her kitchen. And they do that in court. They have a lot of trials where they go on site and they reconstruct things and they have individual people do it. And you could have the supervision of a proper chef. And you don't have to have poison, you can have something instead of the poison. We could still use mushrooms, but you could just have different varieties. And, you know, pretend that button mushrooms are the poisonous ones and pretend that champignons are the good ones. Put it in there, see if you can do it, and make sure that there's none of the button mushrooms in the champignon recipe, or, you know, and see if you can do it. Can you do it in her kitchen? I want to know her kitchen. I don't want to know some random MasterChef kitchen. I want to know her kitchen as it looks. And then I want to see if having it on 4 grey plates, which again, there's no evidence there if it was 4 grey plates other than his testimony. I want to know if that's even possible. Because that's the thing that they needed to answer. They don't need to answer, oh, did she have a dehydrator? Oh, did she dispose of it? Because tell you what, if she had a dehydrator and she disposed of it and she cooked 6, she's guilty. If she had a dehydrator and she disposed of it and she cooked 1, she's not guilty. It's irrelevant either way. And that's the same thing with her having mobile phones and her foraging and all this sort of stuff. It doesn't lead to the result. If she cooked 1 meal and therefore she ate that meal, and the only reason she didn't die was because she got sick and she vomited later, whether or not that was deliberate, she's not guilty. Now you can argue, and I know there's an argument that you say, oh well, she ate the meal, she knew she was going to get sick, she made herself sick. But the thing is, that is not a guarantee to get rid of the poison. If it worked, it worked, but it's not a guarantee. And if she fed it to her kids, because they also ate the leftover, but scraped off the mushrooms, that's not a guarantee. They still could have been poisoned. So, if she did that, she's overly risky. And the thing is, the prosecution are not alleging that. So, yeah, okay, so you can sort of imagine scenarios beyond what the prosecution says. You're allowed to do that. But, legally speaking, that can't be a reason to find her guilty. And we can go the same way in defence. If you're going to consider that, I'm going to consider from a defence point of view something else that wasn't argued, which was that we don't know where these death cap mushrooms came from. And people in Leongatha keep their doors open all the time. And she had someone that wanted to kill her husband. What is to stop him from going into her home, seeing some edible mushrooms in the fridge, swapping them out from some death cap mushrooms that he found, and then she doesn't know where they came from? What is to stop that being a scenario? We haven't investigated it because he's not on trial, and he won't be on trial even if he did it, because you're not going to trial 2 different people, charge 2 different people for the same offence. The prosecution would never do it. DPP would never do that. There is 0 chance that he will be questioned about that, regardless of the level of evidence against him. So even if he did that, unless he just admits to it or something like that, he's not going to be tried for it. So what is to stop that from being a scenario? He had motive, he had reason, he had opportunity, and it fits all the known facts. So what is to stop him from doing that? So if you're going to imagine for yourself, okay, she cooked it, she ate it, and then she made herself vomit, even though the prosecution hasn't alleged it, even though neither side has that as a possible fact, I think that you should also consider the possibility that he swapped her edible mushrooms with death caps. Otherwise, you're not being fair. You've got to either do both or neither. If you do neither, all you need to consider is whether or not she ate the meal. You do not need to consider anything else. And I was looking at the judge's instructions, and according to live blogs, and again, we're not getting it's not videotaped live or anything like that. We're getting live blogs. They have restrictions on that. I don't know how accurate they are. I know that they are getting in a lot of trouble with several successful lawsuits and things coming from the judge, from the court, saying to various media outlets, you guys are reporting on it incorrectly. pull it back. Now, there's some things which are just suppression orders with the kids. We'll say just, but they're putting the kids' names and details and stuff to identify them. I don't know what else they were putting in there because we don't know, but there's a lot of evidence of a lot of media inaccuracies in relation to this. I'm not just saying media bias, but just lying and a lot of stuff to do with this case. So I don't know how much I can trust when the media is saying these are the judge's instructions. But if the judge's instructions are, this case is extremely complicated, I am wondering how the judge is behaving. Because to me, if I was looking at that through the lens of an appeals court, so let's say she's found guilty, and then let's say that she appeals, or her lawyer does, and they look at this behaviour, these 4 days of judge's instructions, which are all focusing on completely irrelevant pieces of information, then, and if it is accurate as it's described in certain media outlets, I have to wonder if the judge is behaving himself, if he's doing what he should be doing, because he's supposed to be neutral. Well, he's required to be neutral. It's not just supposed, like there's a legal thing to be neutral. And if he's not neutral, if he's presenting it as a prosecution win, as the media outlets are suggesting, then yeah, I think that would be grounds of appeal. So it's improper conduct by the judge is grounds for an appeal. And that's why judges are usually very careful. So I'm not saying that he is doing that, because, I mean, it could be that the media are misrepresenting him. The other thing is there is a bit of a stretch, I suppose I should say, where you can sort of do things you shouldn't be doing, but as long as it's not too bad, it's okay. So it's not to say they would definitely win on appeal based on his behaviour, but it is worrying. It's very worrying to me to see that, because what he should be saying is to simplify it for them. Now, obviously, the prosecution have claimed that there were 8 inconsistencies in the defendant's evidence. So only in Erin Patterson's evidence, only when she took the stand, which she didn't have to do. So she voluntarily did that. So in other words, if she hadn't taken the stand, they wouldn't have had a case, is what that's what they're now saying. Which is an interesting thing. And the thing is that supposedly the defence said there were 5 witnesses. Simon was one. We don't know how many others. We don't know who else. We know there are 4 others. We don't know what they said, because the media's not reporting on what they said. We know there's 5 of them. Don't know who they were. Don't know what they said, because the media just are leaving that out. They've got 5 people the defence say lied, or were inconsistent at least. And inconsistent means that like one part is different to another. In American law, that would be impeached. So you can impeach a witness. I'd love to use that word. In Australia, we just say inconsistent statements. And it's a slightly different meaning, but we'll essentially say that it's essentially the same. So apparently 5 people for the prosecution said inconsistent things. One was Simon. Don't know the other 4. And apparently Erin, and only Erin, said 8 things that were inconsistent, according to the prosecution, where because she had to give evidence before the trial began, and she said one thing there and something else in court. And the prosecution claimed there were 8 times where she said something different in court to what she said beforehand. And the defence claimed 5 different witnesses. We don't know how many times total, but presumably at least once each, and maybe more than once. And I think it may have been 2 or 3 times for Simon alone. So that pushes it up to 7, and if anybody else said more than one thing, then it's at least 8. So there may be more lies told by the prosecution than by the defence, is what I'm saying. 5 people told lies for the prosecution. 1 person supposedly told lies for the defence, and that was the defendant. So if that's the case, then, and the prosecution wins, then you'd almost say the prosecution would have lost had she not taken the stand. In other words, don't take the stand. That's what people always say. They say if you're a defendant, don't take the stand, because they can manipulate things, they can make it seem like you're lying, and all this sort of stuff, and it's just not worth it. So, And maybe this is a good example of this. You shouldn't lose because of such a decision, but I mean, there's a lot of things that shouldn't happen that do. But anyway, so look, it's quite worrying how it's being reported. If that is accurate reporting, then the judge is not behaving himself. Now, whether that leads, I don't think that it rise to the level of him getting censured. I think that it would rise to the level of being used in a court of appeal against him and against this case, if she's found guilty. Because it's inaccurate behaviour, it's inappropriate behaviour, and it's biased towards the prosecution. But, on the other hand, if that is not what he's saying, and that it's just what the media is reporting, then the media outlets that did this should be reported, should be sued, and a number of them have been sued for different amounts of money, or fined, or whatever you want to call it, and they should be forced to make a retraction and report more accurately. Because at the moment, they're reporting things that make it look like the judge is misbehaving. And if he is misbehaving, then they should be reporting that. But if he's not, then they absolutely should not. And in fact, there's an argument that even if he is misbehaving like that, they shouldn't be reporting it anyway. And I mean, I think on the balance of probabilities, based on how inaccurate the media have reported on other aspects of the case and how many have been sued, I still think that it's more likely that the media are misreporting it. Or maybe there's some truth to it, but they're presenting it in a way that makes it look like she's already been found guilty, and that the judge is essentially saying that, yes, she's guilty. Because the thing is, the judge should be saying, this is what you have to decide. And what they should have to decide is, did she cook the meal and eat it? Did she eat the meal? If you find that she ate the meal, then she's not guilty. If you found that she didn't eat the meal, then she's guilty. And you shouldn't even get to looking at anything else, because if you find her guilty, if you find that she made the meal, any other evidence that doesn't lead to that doesn't matter, because if she ate the meal, she's not guilty. And if you find that she didn't eat the meal, no other evidence is relevant. So the whole thing should be focused on, did she eat the meal or not? And the fact that it's not shows, I mean, I don't think that the prosecution are doing the wrong thing by misleading the jury. I mean, you're not meant to. But if they're doing that because they can't legitimately win the case, then fair enough. I mean, you can certainly imagine that, you know, like, let's say you're on the prosecution and you've got a case you cannot win. So you go, all right, I'm going to do a Hail Mary to completely confuse the jury, completely confuse the judge, confuse everybody, so that I can hope to get a win. That's a decent strategy. It's a decent strategy for the prosecution to do if that's the only way they can win. And I'd say on the balance of evidence, that's what they're doing. I think that defence missed a trick by not recreating the meal. But I'm going to, look, I was going over this before, I'm going to suggest that the defence did suggest to recreate the meal, and the prosecution objected, saying, oh, this can't be accurate, something like that, and the judge went along with it. Now, I would argue the judge should not have blocked it. I can't guarantee that the defence asked that, because it could be, like I was trying to say before, that the defence says, oh, well, she's already guilty. I don't think that's even in the ballpark. But it could also be that they're saying the defence didn't think about it and they were incompetent. It's possible sometimes defendants forget things, sometimes defence attorney doesn't ring a bell with them. So too busy focusing on the wrong thing. I would argue that's a ground of appeal. So either way, either the defence forgot to do it, in which case it's an incompetent defence, or if they did do it and it was blocked by the judge, I mean, who cares if the prosecution are meant to say no to it? That's not the problem. The problem is that the judge should have allowed it. And if the judge has not allowed it when it's been requested, that's a grounds for appeal. So we have a number of grounds for appeal if she's found guilty. There's also the fact that on the balance of what the evidence is, there's no way that the jury could find her guilty. It's not possible, because it's not possible for her to have cooked separate meals. And even though you might say, oh, well, that's because they didn't present, they didn't redo the cook. Okay, but even without that, I think that the jury should have realised that she couldn't possibly have cooked separate meals. And I mean, I don't even care about the plate evidence is irrelevant. I mean, I know that there's this focus that she said inconsistent things and she lied, and she's admitted to lying. And that is problematic. And this is the thing, I've seen cases where people have not done something, but they've lied about not doing it and they've been found guilty. That has happened. That does happen. Because that can mislead a jury. And you get wrongful convictions from that. Does that mean that they're guilty? Probably not, but it can sort of hint that there's something else going on. So that shouldn't find a guilty plea, but it should mean, hang on, we're going to look at something else. And then that, eventually you're going to get your gotcha moment. But the prosecution never got a gotcha moment. They caught her lying, good on them. But where's the gotcha moment? Where's the bit where it proves that she definitely cooked that meal? That she definitely cooked 6 meals? There's no gotcha moment on that. They failed to get it. They couldn't get it. And the thing is, they have to not only get it as a possibility, they haven't got it as a possibility, but even if you say, oh, but in theory you could do it, no, you don't. They don't win if it's an in theory thing. They have to say, this definitely happened. I don't even think you can get to the in theory this happened. I think you have to say there's no possibility that this happened. That's what the evidence says, that there's no possibility that she cooked 6 separate things. So I mean, if the prosecution had found a set of leftovers and it showed one parcel cooked separately and that one didn't have any death caps in it, they got the smoking gun. They didn't get that. Even if they'd had Ian, who said it was an honest witness, if he'd said, oh, she was trying to kill us, and if that confession, instead of being, I've got cancer, which she didn't have cancer obviously, if that confession had been, oh, I brought you here to kill you, and he'd said that, oh, probably not quite enough to get a conviction, but you're a long way there. But they didn't get that. If there'd been evidence of the plates, I don't think that would have been enough on itself to get a conviction, but might have got you there. Might have got you a little bit of a closer step. So why is this a 9-week trial? I would argue that it should be a 2-week trial, maybe a 3-week trial. Oh, I mean, murder trials are often 4 to 6 weeks. That's pretty normal. I'd argue that you didn't need 2 days of prosecution, closing statements. I think an hour was enough, maybe 2. And you didn't need 2 days of defence closing statements. Again, an hour or 2 was enough. And you didn't need 4 days of judges' instructions afterwards. Again, an hour or 2 is enough. You could have done all of that in 1 day instead of over what is now 2 weeks. And I'm going to suggest something here, that the reason that the defence had such a long closing statement was because the prosecution did. And the reason that the judge's remarks are so long is because the prosecution and defence's remarks were so long. And the reason why we have to go into all these detail is because the media are abject lying about everything. Now, has the prosecution misbehaved? I don't think so. They're doing their best to present a case that can try to win. And that's their obligation. There's no evidence of prosecution misconduct. Now, the judge may have engaged in inappropriate behaviour if and only if what the media is saying is accurate in the judge's remarks. And even then, whether it rises to the level of him facing censure is another issue, because it's a very high bar. Like, the judge can do a lot of things that they're not supposed to do and not get in trouble. And I mean, even if there is an appeal against it, it doesn't mean the judge loses their job, even if the appeal is successful. So, for example, if we had the George Pell case where he was found guilty and then it was overturned on appeal due to jury misconduct, the judge is still a judge. Judges have appeals heard against them. They even lose appeals that when they agree that they were guilty, even when it's proven that the judge had remarks that were inappropriate, which wasn't the case in the George Pell case. That wasn't the fault of the judge, that was the fault of the jury and the media. But there are certainly cases where it is the fault of the judge. So I guess the difficulty would be, if she is found guilty, what would the basis of the appeal be? Now, I don't know if the judge did say anything wrong, because, I mean, you could have that, you could have the jury, because they couldn't possibly find her guilty on the balance of evidence, let alone beyond a reasonable doubt. They can't find her on a possibility. There's no possibility of finding her guilty, even if the bar was, it has to be theoretically possible that she killed him. Even if that was the bar, it's not theoretically possible that she deliberately killed them. So look, it is possible that she put the mushrooms in. We don't know if she put the mushrooms in or someone else did. And we don't know if that someone else was Simon or someone different, someone who's not Simon. And we don't know why they did it. So we don't know that. Although, no, the defence hasn't suggested that anybody else did, but it is possible that somebody else broke into the home. Now, why they didn't suggest it, I don't know. I've seen, maybe they did suggest it and the media just hasn't reported that. I would have thought a competent defence would at least suggest that. Maybe they wanted to suggest it and the prosecution said no and the judge blocked it. It's possible. But I've certainly seen a number of cases similar to this in which the defence would suggest that somebody else did it, even if that somebody else hasn't been charged. Because it's about, the defence are trying to introduce doubt, while the prosecution are trying to say it's open and shut. Does this feel like an open and shut case when it's over 9 weeks? With 2 days of prosecution closing statements, 2 days of defence closing statement, and 4 days of judge's instruction, does that feel open and shut? No. When you've got things that should have been asked but weren't asked, or at least the media haven't presented them. Again, we don't know what bits the media's missed. I've looked at different media sources, and for some things, one will say one thing and another one will say something else. And it could well be they're both true, but they're just sort of picking out a snippet, and it's a different snippet. So clearly, if they're doing a 20-minute summary of a 5-hour day, that's about how long the court days are, and they're doing a 20-minute snippet, they're not going to present the whole 5 hours. And now they should be summarising the 5 hours, but apparently they're not all the time. They're interpreting it in their own little ways. So with that in mind, it is quite possible. Look, I know that they didn't go ahead with a recreation of the meal. We obviously didn't have that. They should have. They would normally in a case like this. So either the defence forgot to mention that, or it was blocked by the judge. So the prosecution doesn't have the power to block it. The prosecution could object to it, and this would never get into the media. The judge would decide whether to allow it, and if the judge didn't allow it, then that could be very harmful to the defence case. I think the defence should have had a professional chef come on board and explain how difficult beef Wellington is, because I don't think most people realise how complicated it is. I don't think the average person even knows what dish that is. They probably think, oh, is that like a roast or something? Yeah, it's not like a roast. It's an extremely complicated meal where you have to wrap things up and spread things around and all sorts of things with really expensive meats and weeks of preparation and all this sort of stuff. But it's an odd choice, I have to say, if you're going to poison someone. If you're going to poison someone, you don't normally have one of the most complicated meals you can ever imagine. You're going to have a simple meal. In fact, if you want to poison someone, just say, hey, have a mushroom, ha ha ha. Or you just put them in their fridge. It doesn't look like a poisoning case. And I think this is what, well, this is probably not what interests people, but there's never been a successful case against someone for death cap mushrooms poisoning. Never. Not anywhere in the world. So I've checked this. I mean, if somebody finds one, good on them, but I could not find one. And in fact, it's very rare to get deliberate poisoning cases, and when you have had them, they're open and shut cases. Because poisoning is one of those things where it's difficult to prove. And it's always been difficult to prove. So if you look through history, there's been lots of people that were poisoned, and most of the time they didn't even know who did it. And even if they did know, they couldn't do much about it. It'd be very rare to prove that one person poisoned them. So, and when you have pseudo-historical dramas like the Game of Thrones thing, there were poisons in that, you didn't know who poisoned them. Because that's what poisoning's like. You don't know who's done it. You don't have a case where the cook does it and then they're the only person that could have done it. That's not how it works. And logically, it's not how it works. In fact, if you had that situation, you'd probably ordinarily think, oh, somebody else must have given them the mushrooms or put it in there. And that someone else is almost certainly Simon. I can't imagine anyone else. Now, maybe there's a scenario where somebody else thought it, but based on what we know, there's nobody else that could have done it, or certainly nobody else that had the motive that we're aware of. Maybe there is someone else on the side, who knows. But that's the thing. They haven't established that she got the death cap mushroom. She's not sure where she got them from. And, you know, there's so many cases in history of people cooking something, even going to jail, even being executed when someone else poisoned them. Not the person who got convicted. They're almost a fall guy. And they're real assassinations of historical figures. So, you know, we should learn from history, but we don't, do we? But yeah, it's... I'd like to say that I don't know, but it is such a clear-cut case, such a simple case, that there shouldn't be any doubt in anyone's mind that she couldn't have done this aiming to kill them. And I'm going to reiterate that beef Wellington is an extremely complicated dish. It's easy to mess up. And if part of that mess up means that you think a dehydrator is going to be a better idea and you end up adding death cap mushrooms, I mean, I didn't do it when I cooked it, but, you know, when you're trying to cook something really complicated, you can mess up. That's what happens when you do something beyond your level. Maybe you sort of look at those recipes and you go, oh, that's easy. It is not an easy thing to cook, and you can mess it up very easily. So there are essentially, well, there's two options, and then you can split it into two again to make four. So the two basic options are either number one, she cooked it with 6 separate parcels, one aimed for Simon, with an attempt to kill. She never ate it. And the second option is she cooked it with one and she ate it. Now you can split that up again. If she ate it, you can either say she ate it and she accidentally threw up and that's why she survived, or that she ate it and she knew she was always going to throw up and that's why she survived. And the second option for the other side of it is if she did cook it with 6 individual parcels, that she didn't know that that was going to kill them. Because that doesn't absolutely prove it. It's likely, I'll say. And then you also have the fifth option, which is that Simon, or someone else, but it's almost certainly Simon, put the death cap mushrooms in. Now, I'm not saying he did it on the day, but he might have done it a month or 2 months before, that he put the mushrooms in, the death caps in, replaced them in her fridge. She's probably a very messy person. He probably just slipped them in when he was visiting. You know, I mean, he does visit. It's not like they're not allowed to see each other or anything like that. They're not divorced. They're separated and he goes over all the time. So he could easily have swapped them out. So they're the options. Which one's the most likely? Well, it's most likely that she cooked them herself and it was an accident. And she ate it. And she ended up vomiting and that saved her life. By accident. That's the most likely scenario. The second most likely one is that Simon put the mushrooms in and she had no idea that they were in there. That's the second most likely one, in my opinion, from what I've analysed. And the third most likely one is that she cooked it, she ate them, and she deliberately vomited because she knew there was poison in there. And she was taking a bigger risk than she thought. The idea that she cooked them into 6 parcels is impossible. So I'm not even going to consider that as an option. So if you're sticking to the letter of the law, you can't even consider the only way that she actually could have done this, which is that she ate it and deliberately threw up. You can't even consider that because the prosecution has not suggested it. But you can actually think about it, like in reality you can, I can. But if you're saying, I'm not going to consider the possibility that Simon did it, okay, that Simon put the mushrooms in there, okay, don't consider it, it wasn't suggested by defence, then I'm going to say, you also can't consider the possibility that she ate it and deliberately made herself vomit so she could survive. Because that's not open to you. It wasn't suggested by the prosecution. So are you going to stick to the rules, or are you going to go outside of them? Either way, you can't find her guilty. Either way. Anyway, that's it from me. Bye-bye now.